Okay, good afternoon, everybody. I'm a bit worried about the fact I've come after Chris's talk about sensory. We're talking about use of force matters in themselves. But just to give a little bit of context, most of my kind of background, so where my kind of knowledge comes from in this area is from kind of policing itself. So it's just that some of the references I use come from that particular area. But thanks to people like Steve Hunt, who took me through my early days with Maybo, got me to see the wider focus around supporting people. But we think about different skill sets then to begin with, in terms of physical intervention itself, and certainly from an SIA, Security Industry Authority point of view, there are something like about 20 different skill sets out there, which of course creates its own issues, doesn't it? Because some of us familiar with the term approved techniques? Yeah? What do we mean by approved techniques? What is an approved technique? Anybody, please? Recognize Maybo? Yeah? So if we don't follow an approved technique, it's wrong? Is that what we're saying? No? Sorry. Okay. Yeah, can we justify it? But the point is that we use terms like approved techniques, though, don't we? Yeah, which kind of implies to people who don't understand it the same way as us, if what you did wasn't approved, then it must be wrong. Particularly people who don't understand it from our point of view. And that's one of the frustrations, isn't it, which kind of gets us into areas where it's difficult then to try and justify and rationalize what we did. Yeah? So we think about training in itself, and training must be safe and effective, but at the same time, we think about, don't we, reality-based training, and those factors come into play. Yeah? And some of the areas we need to be aware of, particularly for trainers and employers, is the amount of scrutiny now which is coming up regarding people where they've used force and it's gone wrong. Yeah? There's been an allegation about excessive use of force. Yeah? We think about it from an internal point of view, let's say within our workplace setting, and we have a view about a challenge of use of force where it hasn't perhaps gone well. Then often, as trainers, we're called in, aren't we, to give a view on that particular, let's say, use of force allegation or incident or technique that was applied. Yeah? And from that perspective there, we come into the realms of, this bit about expert witness. Yeah, so we're already starting to do that work. But what's certainly starting to happen more now from my experience of getting involved in looking at cases is trainers are being called into account more and more these days, particularly around training that may have occurred some time ago. Bill referenced the fact that, we've come across each other many times, cases in court, and sometimes, last year we were involved in a case where the training was involved in 2020, yeah? And the trainer was called to account to evidence what he did and what was covered in that training going back to 2020. Well, I don't know about some of you in the room, but I struggle to remember what I did last month. Yeah? My apologies, 2020, sorry. Sorry, I do apologize. You get version 2. Sorry, future. It's a century bit, isn't it? Sorry about that. I do apologize. Okay, it's a century. But 2012 is what I meant. I do apologize. Sorry. Okay, going back to 2012, though, yeah. Okay. But, it's difficult to remember, isn't it, what we did last year? Yeah. Certainly when those records are called to account, though, which kind of creates its own factors from there. But importantly, outside of that, we get involved in incidents where a severe injury has taken place or has resulted in a death. Because when we think of areas where people have had to use restraints involving people on the ground, whilst it's not an area we want to go to, but in certain situations and incidents, we've come across cases where somebody's been held on the ground for 22 minutes. Yeah? Which a lot of us, it's hard to envisage, isn't it, why somebody was held on the ground for 22 minutes. Part of the evidence from the security officer who held that person on the ground for that period of time was he was that violent that they'd radioed for the police to arrive. And because the person was still struggling on the ground, they kept hold of him, but it took the police more than 22 minutes to get there. Yeah. On one hand, common sense kind of prevails and says, well, why didn't they try and readjust his position? Why didn't they try and sit him up? Why didn't they try and stand him up, et cetera, in itself? But the officer around the security staff were in an emotional state at that time, felt the need to keep him on the ground due to his previous behaviours, having to get him down there in the first instance. And I'm not trying to justify their actions, I'm just trying to say that was their account of their rationale for why they felt the need to keep him there. Yeah, and certainly for most of us in the room, we're struggling to get our head around that, aren't we? 22 minutes held on the ground. yeah, by more than one person. So it kind of throws those factors into place. So one thing about expert witness then, is people like trainers in here and others who are helping the courts come to a decision where their expertise doesn't cover it enough to look at the intricacies of a case or a situation or techniques within themselves from a further afield matter. Some of it needs to be evidence around professional practice guidance. Where are we getting the evidence? Where are we getting the rationale for our decisions? For example, my introduction is I've come from a policing background originally. But as happens on occasions, I'm called into question to review a case where maybe one of your colleagues has been involved. Then the question is, what do I know about health and social care, NHS? What do I know about other sectors? Well, that's where we look at and scrutinise the professional practice guidance, and the details and the documentation that sits behind it. If you think, when solicitors instruct us as expert witnesses, where there's been an allegation of use of force, this is the kind of information they're looking for from us. Yeah? If we see that a person goes to solicitor, he, she, they believe they've been wronged. Maybe they've been injured. Yeah? So they've gone to seek a solicitor's advice and guidance, and they want to right that wrong. And solicitors contact people like myself, Bill, and possibly other people in the room, excuse my ignorance, and want to instruct us on our opinion regarding looking at what they refer to as use of force incidents. Can we give an account of a use of force where maybe someone's been strained on the ground, where maybe someone had a broken arm or a broken limb, and give our view on that. And often these come on the back of a phone call or an email or a letter which just arrives out of the blue, within itself. And within that, you can see some of the points that are raised, they want to know from us, was the force used necessary in the circumstances? Well, as we know, the only person or persons who can truly answer that question in the first instance are the people applying the force. When we look at about appropriate, proportionate, necessary force. But they're looking at us then to give an opinion around that based on the evidence that's presented. Was the force used excessive? Well, the question around, isn't it, if somebody's died as a result of a restraint, then they're looking at, was the force a significant contributory factor towards that death? Which on one hand, we could argue, well, had the person not been restrained, he or she would not have died. But we're looking at it much more complex than that in terms of at what point did the person die during that restraint? And that creates one of the bigger issues, of course, isn't it? Because from a coroner's inquest point of view, if we had the time of death, we could work backwards regarding this is the time of death, what were the actions leading up to that death? But if I go back to the case in Essex a number of years ago, the person was held on the ground for 22 minutes. At some point during that restraint, the person died. But nobody was able to say at what point the person actually died with themselves from there, which then creates the factors and issues from there. Oh, please, if you've got any questions, please ask. So, please, just in case anything comes up. We're asked whether the technique and arm entanglement was applied correctly. Well, I come back to my earlier question. I take your point about Maybo-approved techniques, by the way. But, I do follow it, please. But the point is, though, isn't it, what we do in training doesn't often reflect reality. And, of course, that's the issue, isn't it? Because training, quite rightly, is a safe and effective environment. And whilst we want to make the training reality-based, but it needs to be safe first, doesn't it, then effective. And of course, that can create some concerns within itself because we have these discussions, well, is the training kind of fit for purpose? How far do we need to go with that training? So we think about things like arm entanglement, for me, generically taking somebody, excuse my air demonstration, taking somebody's arm up the back and applying pressure. I don't want to get into the wrongs or rights of that. I'm just saying that's an arm entanglement technique, in itself. But if that technique's applied on somebody who doesn't want to be cooperative, who isn't going to calm down or can't calm down because of the pressure that's being applied to them, then if it's put on with, let's say, a little bit more force, then we can see how easy, can't we, injuries may occur or breaks may occur, within itself. And then we're back to the same old question, aren't we? Unless we're using force for a greater good, or we're using it to prevent further harm, what was our rationale for doing so? and that difficulty around if we're causing injury to a person, and we've got a duty of care over or for, then the contradicting issue of we just cause harm or injury to that person, particularly severe harm, severe injury, or restraint death in certain cases. Okay. So employers' liability, there's certainly been a shift in 2019, try and get my ears right. Yeah, sorry. There's certainly been a shift in 2019, though, where I've certainly seen now more awarding representatives from more awarding organisations being called into court. Yeah, trainers, as I say, being called into court to give a rationale behind what the policies and procedures were, what were the methodologies around the training that was taught. Yeah, linked to the person's rationale for delivering that training. Because often in training, don't we talk about common law self-defense, honesty or belief, imminent danger, etc. We talk about using ABC reporting. But within training, do we get enough time to go into statement writing, for example? We do incident logs, and a lot of those are electronic now, aren't they? We're going through boxes, which is very good and expedient for many situations. But when we start to get to statements, how often are the colleagues who are supporting at this level familiar with writing a statement? And forgive me for using the cliche, but if it wasn't written down, it didn't happen. And just about everybody in the room is nodding, so I say forgive the cliche, but that's the reality, isn't it, which starts to occur at this level? Or all levels, of course, but that's the reality that starts to occur and kick in. So from an organisational point of view, we think about our corporate manslaughter and homicide legal obligations. As I say, I was from Kent. Most of you know, some of you know, but it's easy to find out. We were delivering training once a number of years ago, what we used to call then violent person training. And some of you probably done training where you wear the padded suits and the like and stuff like that. Try and make it safe. We've got safety officers in place, go through the risk assessments. And during the training, a member of staff got injured. Quite rightly, the injury was reviewed. Due process took place around the training. The incident went up to HR, who instantly said, we're going to ban the training. We can't have people being assaulted in training. But additionally, part of the allegation that came in from the person who was injured, the allegation not only named the trainer who they believe caused the injury, but also named the chief constable, which at that time was a massive shift within the organisation. Because up until that point, if somebody had unfortunately suffered an injury, it was just a case of Kent Police as a broad heading, and it didn't specifically name people. So certainly from a Kent Police perspective, I'm sure other organisations come post-2007, it was a significant shift to around accountability, themselves coming into play. We think about the Health and Safety at Work Act and stuff around foreseeable risk. I'm not going to labour the point, but our duty of care. We go back to again when solicitors are instructing us, we know the information and the professional practice guidelines, policies and procedures we're looking for in terms of supporting the solicitors to support that client. We think about organisational policies and regulations. Our policies and regulations, aren't they direct about who should receive training? If we think about a tiered approach, if you don't mind, if I can use generic reference, maybe the admin staff are receiving training once every 3 years for half a day. More frontline staff are interacting and engaging with people, are receiving a full day's training. And those people who work in the highest risk area, either 2 days of training, some of it involving physical intervention, non-restrictive and restrictive holds. With the policies having directed that training, then what happens if a member of staff doesn't attend training on a particular day? What's the risk assessment around his or her deployment having failed to attend training? What's the deployment capability? Particularly for the higher risk person. What are the questions that are asked if that person then gets involved in the use of force incident and it goes wrong? Where's the accountability lying? Would the individual staff member who didn't attend training? Or would the management structure, senior leadership team? But importantly, what does our policy say about that person who hasn't attended training? And what's the risk assessment process post them not attending training, and the direction about when are they going to attend the next available opportunity for a course? There are lots of reasons why people don't attend training, lots of valid reasons, but there's still in certain organisations we review where there is that gap around people haven't been trained for a good number of years, but the policy says every 12 months people should receive training. Yeah? And certainly from a solicitor's point of view, and us within the room, it starts to beg questions. Well, if your policy is saying this and we're not enforcing the policy, what's it saying about the rest of the standards that we're operating within the organisation? Whilst that might seem like a very unfair statement, but you can appreciate where external people are coming from with that. Yeah, unfairly so in many respects. Yeah. But the individual job role around it as well. I don't want to go for the 5-step plan, but the hazard and risk. But have our individual job roles been risk assessed to that level? Yeah. Or are we looking at a kind of one size fits all? Yeah. So that again, isn't it, comes up as a factor. The course specifications. Sorry, I'm going to think about this. 2018, last year. It's getting quite embarrassing now, isn't it? 2018, last year. There was an incident involving the prison service. 12 people were around an individual they were supporting in prison who had subsequently died during restraint. 5 people had hands on. 7 people stood around in very close proximity. When we received the instructions to review that case, of course, one of my first points of reference was, well, let's see the training manual and guidance for that particular prison service itself. We were initially met with a lot of resistance, but obviously through the legal jargon, we were able to get access. And the interesting point around the access, as I went to that prison service, believe it or not, albeit it was 2018, I had to remove all my pens and my mobile phone, etc., and I was allowed to take a pencil and a pad into a room to review their manual. Okay. And with respect, there's nothing different in the prison service manual as there is to all of our manuals, apart from the language, but they were quite insistent about it. But where I'm going, though, more importantly, my view about their manuals of guidance was that they were outdated, which did not sit very well with them, as you can appreciate. But I felt their manuals of guidance were very, very dated. Reference a lot of things that we in this room have been doing for a good number of years. And we think about issues like excited delirium, etc., factors like that. 1 page within a significant manual of guidance. So again, whilst it might seem unfair on one hand, but we think about the lack of training their officers are receiving regarding the wider issues of, I'm going to say, support for an individual before it goes wrong. Because whilst my focus here is linked to use of force, but as we know, all of the strategies go back to not having to use force. But the reality is from time to time we have to do so, don't we? What are the staff's training records? Okay, all I can say to you is, please, you'd be woefully, woefully surprised at the gaps in people's training records. Or the lack of information that's presented around people's training records. But again, it begs the question, doesn't it, about the quality of standards of review that's going on within that organisation? If the records aren't kept up to date, what else is going on behind the scenes? And sadly, they've probably got people like us who are very committed, and very good at what they do, but because the records aren't supporting that, it lends itself to a question. Okay, so for us as trainers then, how many times will we be running a training course and we get the what if question? Quite a few, isn't there? All right, there comes the point, doesn't it, with what if questions. How many can we do with respect? But where I'm also trying to go to, though, how many times with that what if question we answer it with sincerity, then weeks, days, months later, somebody comes back and says, Trevel taught me this on a course. And I go, I have not got a clue what you're talking about. Well, you remember, I asked you that question on the course and you answered it. As far as that delegate, that staff member is concerned, because it was taught to them on training, it was part of the syllabus. And please, not for 1 minute, I'm not saying not to answer the questions. I'm just trying to make the balance of the point of, depending where that question's going, make our own notes and records, please, That's the point I really want to make with that. Because we want to be supportive as much as we can, don't we, It comes into play, The trainer qualifications and CPD, within Maybo, we have a good process and good referencing guidance, but for all of us, keeping our CPD records up to date, because arguably once we're trained, other than kind of expanding our knowledge and understanding experience in the subject areas, for lots of us, there is no further to go, so to speak. Yeah, so we're just trying to broaden our knowledge, but what's the evidence reference behind that? Yeah, we as the trainers, and in that first instance, the training needs analysis, as Bill quite rightly mentioned, because that is becoming much more of a bigger focus nowadays. Yeah, particularly with the bigger organisations where we still have the kind of one size fits all, and that's not meant as a criticism, but we always know for years it's been, what's the thing that suffers the most? Training, isn't it? Abstractions for training. Yeah. So we come back, we get very limited contact time with people, particularly when we think about physical intervention. Yeah. Then we're trying to kind of rob time, aren't we, really, to try and manage physical intervention and address and support people's needs, which creates its own factors within there. But who are we going to train? What is it we're going to train them in? Yeah. And what's our methodology for doing so? There seems to be more and more now, doesn't there, this business about online training around physical intervention coming into play. Yeah. And again, it kind of creates some views, doesn't it? If you're doing physical intervention, but to do it online. Yeah. Well, if you're shaking your head, I'm not disagreeing with you, but I'm just saying, but it seems more, doesn't it? We think about the methodologies. Yeah, where organisations are significantly letting people down in that particular area comes into play. Yeah. Okay. But as trainers, what are our lesson plans saying? Now, I don't mean the generic lesson plans. I mean the specific lesson plans for the lesson we're conducting on that particular day or period. Yeah. Because whilst many lessons follow the same format, but with the different individual needs of people who attend our courses, and to try and address that within the broader learning outcomes, to link in with the assessment criteria, sometimes we're going, aren't we, within the bigger learning outcome where the individuals need us to go. Yeah. It's that specific reference in that particular area, isn't it, which then can create some issues post-incident when there's a review, and our recollection from records was A, B, C, but the individual who's facing allegation of use of force, excessive use of force complaint, has a different recall, X, Y, Z, can create those factors behind the scenes. Yeah. And then we think about post-incident management, don't we, in post-incident review, the training record, the incident reports. I spoke to one or two people in the room during the past 2 years. Yeah. Again, more and more it's becoming the case where I'm asking to see the incident reports for the people who've used force, and I'm being told there isn't one. Which, like yourselves in the room, it's just, in the same way night follows day. If you use force, you must have an incident, forgive me, but, yeah. But again, we've gone back to it begs what is the employer doing, though, isn't it, in trying to support that individual within the organisation? Yeah? Yeah. Forgive me, as ridiculous as that sounds, but it's not just one case. It's been a number of situations when that's occurred. Yeah? A number of incidents. Okay. We think about it, though, from the operator, the end user's perspective. Yeah? Okay. And about their actions and what they were taught in training. Because as we know, a lot of it centres around, doesn't it? Honestly, held belief, imminent danger, reasonable and necessary to avert that danger, etc., doesn't it? But we come back to, unless we're doing it for a greater good or prevent further harm, greater good, we're trying to stop it before it goes wrong, which creates those issues, doesn't it, in itself for people who don't understand it from our points of view. Yeah? Or prevent further harm, it's already gone wrong, we're trying to worsen the incident of it occurring. Yeah? In our incident reports, which are based on factual evidence bases, well, those subjective views of the individual need to be captured, don't they? They understand. I know we say this in training, but again, for us as trainers, but more importantly for the employers, to review and look at maybe including statement writing within the training. Because the amount of gaps that are left in people's incident reports that we review is significant. Yeah? We can understand why they've done what they've done because it wasn't evidenced. Then unfortunately it leaves it open to scrutiny for other people to have their view around what occurred in that particular incident in itself from there. Okay. Yeah. I was saying about recognised techniques before, and people not understanding it from our points of view. Again, I go back to at one point in police, the old complaints of discipline, as they used to call them, professional standards. We were supporting an officer very late in the stages of the investigation, yeah, who was being disciplined for using a wrong technique and not an approved technique by people within professional standards departments. Yeah. And the crux of the incident, the issue boiled down to, he'd done what they'd called a sweeping kick within policing, yeah, and he'd used his left leg. Yeah. When the professional standards department reviewed the incident and reviewed the manual, the photo in the manual showed the officer using the right leg, and therefore they believed the officer had got it wrong. Yeah? Okay. I don't say that lightly, but what I'm trying to come to, though, the people who are sitting in judgment of us have no understanding about some of the issues we're facing and confronting. You know, whilst on one hand we often talk about common sense, but I appreciate define common sense, yeah, themselves. But as I was sitting there in that room, it was a bit like one of those, I'm waiting for Ant and Dec to jump out of a cupboard and go, ha ha, this is funny. Yeah? It was, you know, is that ridiculous, really, with himself? But we know, we look at methodologies, don't we, and principles, yeah, for themselves. Yeah. And if they can't follow the recognized techniques as was taught in training, then we want the mitigating circumstances for why they had to adapt the technique. Yeah? The mitigating circumstance, isn't it, is the person's behavior, the one thing we can't control. Well, coming back to the incident report, that's the kind of information, isn't it, you and or I need in that report, yeah, to try and support it and see it from the other person's point of view. You know, so when we look at that, issues about human rights, and isn't it, but proportionate to the perceived threat. Yeah? Yeah. We look about the legal and rational basis, don't we, for using force. You know, what was the legal basis behind it, as we know, and forgive me, I appreciate a lot of people in the room deliver the training as well. Yeah? You know, but was it Human Rights Act? Was it common law? Was it criminal law? Was it some other regulation which came into place? But what was that legal basis for using force? You know? Accountability. Yeah? Yeah. Our actions around why did we have to take that particular action in that particular instance, yeah? Or sometimes to do know or not appear to do something around accountability. It's not that we have to do it every time, do we, around the task, yeah? And the necessity test, you know, were there any other alternative actions or options that could have or should have been taken to achieve the same outcome? Does that cross-reference to that issue around perception, doesn't it, doesn't itself from there? Yeah. Yeah. So as expert witness, then our job is to provide, you know, opinion based on facts as presented within the incident report. Yeah? As I say, the frustration for myself and many colleagues sometimes is that I can put myself in the person's position. I can probably appreciate why they've done what they've done, but because it wasn't, excuse the pun, but because it wasn't written down, it's not documented, it's not referenced, then unfortunately other people aren't going to see it from their point of view, yeah, which creates factors. So please, we need to support our colleagues regarding we can't put too much into a statement, but we can certainly leave too much out to cause us issues and angst. Our duties are to the courts to be unbiased about our opinions. So sometimes when we come in, let's say I'm working with a defendant and they want to know about the action, sometimes my opinion is, well, actually the defendant didn't help this situation. Yeah. That's what the solicitors want, though, isn't it? About an unbiased opinion, objective and unbiased opinion overall within themselves. Okay. But let's say more recently, though, it is this bit about training providers being called to question in court, yeah, to give their rationale, yeah, for an opposing solicitor to try and discredit us in court because we have very limited recall about what occurred some years ago, or there's very little or minimal evidence behind it to support those particular actions within themselves from there.